TMC College, Thana.
Okay, good, good.
Yes.
Namaste, madam.
Namaste, sir.
नामियार सर हैं क्या?
Yes, yes, I am here, Dr. Jayant Singh.
Sir, namaste.
Namaste, namaste.
You are not visible. You are not visible.
Not visible. Okay, I will make it visible, sir.
Namaste, namaste.
Namaste.
Yes.
പ്രിയനെ വിളിച്ചിട്ട് എന്റെ വീഡിയോ കാണുന്നില്ല start video stop video hello
YouTube पे
Now you are seeing. Now, Dr. Only Krishna, you are seeing now.
Okay, thank you, sir.
सर जयभावे सर जॉईन नाही झालेत वाटतं.
गुड मॉर्निंग.
जॉईन झाले दिसते. हॅलो.
Yeah.
झालो जॉईन.
Yes, yes.
जयभाव झालेले आहे ना?
गुड मॉर्निंग सर. गुड मॉर्निंग सर.
थँक यू.
Namaste, Nambiar sir.
Namaste, madam. Good morning. Good morning.
Good morning, sir. Suprabhat.
Suprabhat. Vanakkam.
गुड मॉर्निंग.
Good morning, sir.
सर गुड मॉर्निंग.
Good morning.
Good morning, Jaibhave sir. We have with us our trustee sir, Dr. Rajendra Singh sir, and our director, Dr. Usha ma'am.
Yeah.
Good morning, sir.
Pranams to them.
Namaste, sir. Namaste.
Namaste.
सभी को नमस्ते.
नमस्ते मैडम. नमस्ते.
Namaste. Namaste, sir.
I am audible, madam?
Yes.
Yes. नंबियार सर कैसे हो?
हाँ बहुत अच्छे हैं सर, बहुत अच्छे हैं। आप कैसे हैं नासिक में? अच्छे है ना? हेलो।
Enjoying lockdown? You
हाँ,
are
enjoying lockdown,
enjoying
sir.
lockdown?
Yeah, sure. What about you?
Hmm. I have started working
Okay, very good, sir. Very
in
good.
my office. I have started working from 11 to 6. I'm working there.
And Dr.
Yes.
Nambiar
Only
doesn't
not
seem to
courts
have
are not
stopped at
open
all.
yet.
Dr. Nambiar doesn't seem to have stopped at all.
So we are not stopped, sir. We are also working now.
Good morning, Lordship. Good morning. Good morning.
All the while he was in touch with me.
Dr. Madhura.
Yes,
Dr.
sir.
Madhura.
Yes, sir.
Can we start? Any problem is there? We can start now.
Yes, we can start now. Students are coming now. That's why we are waiting.
Okay, we can wait another 5 minutes also.
Yes, sir. We'll start.
Yes, sir.
Yeah.
Okay.
Nambiar sir, your college has started? No, not yet. No,
No, only non-teaching staff, sir.
non-teaching staff is
With
coming.
minimum number of non-teaching staff, as per the circular by Government of Maharashtra.
Correct.
मधुरा मॅडम आता त्यांना तुम्ही युट्यूब लिंक द्या. कॅपॅसिटी फुल झाली, सुरू करा मॅडम.
Okay, ma'am. Okay. Greta, madam. Neha, madam.
Yes, ma'am. Ma'am, it's already on the chat box.
Okay. Chat box में अपने लिंक भेजा है ना YouTube का?
हम मैम 2 बार सेंड किया है.
Okay. So we'll start with now.
Here it is reverse order. We on stage we come first and then admit the students.
Lordship, it's COVID impact.
Yes, sir. And Jaibhave, sir, we can start now.
Yeah, sure. We are ready.
Okay. Good morning, one and all. Myself, Dr. Madhura Kadamkar, in charge principal of Hindi Vidya Prachar Samiti College of Law. Wishing you all great and beautiful morning with joy. Wish you all happy Environment Day. It's my privilege to welcome on behalf of Hindi Vidya Prachar Samiti to all the principals, advocates, teachers, students for the today's online webinar. I'm very much thankful to our management, officer, Dr. Rajendra Singh, our director, Dr. Usha Mukundan Madam, for giving me an opportunity to conduct today's webinar. So now I will request our Honorable Secretary Sir, Dr. Rajendra Singh Sir, to say a few words. Dr. Rajendra Singh Sir. Dr. Sir.
Hello. Okay. Am I audible?
Yes, sir.
You are.
Yes, sir. Yes, sir.
Okay. Good morning, everybody. Respected Justice Vyas, respected Advocate Jaibhave, respected Principal Advocate Nambiar, Director of HUPS Group of Institutions, Dr. Usha Mukundan Madam, Principal of HUPS College of Law, Dr. Madhura Kalamkar, and all my dear participants. I welcome all of you on behalf of Hindi Vidya Prachar Samiti to this webinar. It has been a great source of information for the students and our staff and to community in large to get the guidance of from people like Justice Vyas and Advocate Jaibhave. I wish all the success to this webinar, and I hope to listen to these two stalwarts, how to face post-COVID situation, how to keep ourselves safe, and whatever is good for the society, they are going to guide us. Once again, I welcome all of you. Thank you very much.
Thank you, sir, for your opening remark. Now today, I am pleased to welcome two eminent personalities for the today's webinar. That is Justice R.D. Vyas sir and Advocate Jayant Jaibhave sir. They are going to enlighten on our today's topic, impact on legal education by the lockdown followed by the COVID-19 pandemic and the key role of Bar Council of India in legal education. Justice R.D. Vyas, former judge of Gujarat and Madhya Pradesh High Court, senior member of Inspection Committee of Bar Council of India, a legal expert and a philanthropist. And today, sir will be sharing with us his expert opinion on Bar Council of India's role in reforming legal education in India. With that, I ask you all give your full attention to Justice R.D. Vyas sir and help me in welcoming him to the session. Justice Vyas sir.
Thank you. Thank you very much. Thank you very much. All the esteemed members who were mentioned earlier, so that I don't repeat. Dr. Madhura, Dr. Unni Krishnan, Rajan Singh ji, Jayant Bhave, and others. I'm sorry I don't take too much time in naming all. I am really thankful to the Hindi Vidya Prachar Samiti Law College to have invited me to speak a few words on legal education imparted in India and controlled by Bar Council of India. I would start first of all from the earlier position of just a minute. Earlier position of legal profession. In 1879, there was a Legal Practitioners Act. In 1926, Indian Bar Councils Act 1926 passed. In 1961, the present Advocates Act came in. And under Section 49, the Bar Council of India, formed under the Act, has started its role. The Bar Council's role is to administer the advocate's role in the society, in the court as also outside. In fact, the Bar Council's real concern should be always, as expected by the law, to see that the legal education is imparted properly. I have one idiom: unless you are well dressed, you can't perfectly address. It is, you see, dress means not the clothes, etc. But dressing yourself means imparting yourself with, rather ornamenting yourself with the complete knowledge of law and the whole attire, including the knowledge. It is not only because I remember the other day a lawyer had come in some shabby dress. I had to tell him that unless you are well dressed, you can't well address. Anyway, that's a different matter. I would start with introducing myself, not as introduced by the people on dais, in the sense that so far as the education is concerned, I started my education in 1944-45. At that time, I wanted to become a teacher because teacher was teaching me so many things which I felt that would not have come unless there was a good teacher. So I wanted to become a teacher. Nonetheless, it was fate that in 1955, I remember, I had given education to 5 students, five female students who had failed several times in English. And when I was introduced to them, I was told that they are very weak in English and they don't pass. I myself was also a student along with them. I undertook to teach them English. We all passed together, my students and me. That was my education, and that is what I feel, that education must start from and end in a good educated person, well-dressed person, I would say. The dressed person only can address the society at large properly. Yes, it is not only what attire you are in, but nonetheless, it does affect. See, for example, I had the other day, see, I was preparing for some lecture in some college where I had to deliver little serious lecture. I was dressed in my night dress. I was just trying to understand what I would look like. But in the night dress, I felt that I was not proper. Then, you see, when I went there to deliver my lecture, I was dressed properly and I could see that there was a vast difference between what I was speaking to my mirror and what I am speaking to my audience. That is a part of dressing. Again, if I am not well prepared, that also is dressing. If I am not well prepared, I can't deliver the better education which I am expected to impart. So that is one thing. This is the real role of the Bar Council of India, to see that the people who are in profession are properly dressed in the sense, as I said, well educated, properly educated, and disciplined. There are occasions when we fail because of our unpreparedness. The Legal Practitioners Act gave the powers to the Bar Council to not only register the lawyers, but it has given the powers to grant recognition to the universities, to the colleges, etc. Even the students are expected to have some standard before which they start the legal education. There is a reason. You see, legal education is not simply an education. It is affecting the public at large because you're going to represent the case of the clients, and that is the public at large. So it is very material that you are not only well educated but educated properly. That properly also includes the etiquette, the discipline, the conduct, etc. All those things are required to be done. Therefore, the Bar Council of India has taken upon itself the role of controlling the whole education right from the beginning. Now, why is it necessary to give recognition to the university? What happens is that if the university is nowadays we see that there are private universities and the state universities. Private universities impart the education in their own way. The business has become, education has become rather a business in some sense. Now there, you may not have the quality that is required. Therefore, it is necessary that the university granting the affiliation to the colleges also is recognized by the Bar Council, so that the curriculum, etc., which is given by the university to the students is properly controlled. Nowadays, you know that the laws are going on changes every day. Some laws which were there have become redundant. Some laws which are coming up. So the education has also to attune itself with the demand of the time. The demand of time is going on as changes. Now, you see, for the present, our present subject is what is the effect of pandemic of COVID-19 on the legal education, and what will be the role of Bar Council of India in controlling the education. One of the requirements of the Bar Council education, Bar Council for the education of law is there must be attendance, personal attendance by the students to a certain percentage. It is necessary for the reason that when you are educated, you are educated properly with some practicals. Practicals in the sense that the knowledge which you are acquiring must be from the proper hands. Otherwise, what will happen is that you will be inadequate. You will be inadequate. In order to make you adequate, the educators also must have some qualifications. In that, also Bar Council controls the appointment of professors, etc. Nowadays, I've come across so many. I'm sorry. Hello. So the presence of these students is required for the reason that they have been properly addressed by the proper persons. Sometimes the education, just as I would say, the education given in the college is more often becomes little bit short in the profession. Sometimes the situation so arises that whatever you are told in a simple way may not come through. What happens is that a complication arises in giving interpretation of certain things. Say, for example, discretion of a judge. discretion of a judge ordinarily, as it is said that under in 302 you will be punished for life imprisonment or capital imprisonment. Now you see there the question of interpretation, etc., comes. In such circumstances, how would you interpret it? Requires an expert's say opinion. Now what you learn in the colleges initially is given by the professors who are trained properly. If they are not properly trained, what will happen is that you don't get the proper education. In that view of the matter, the requirement by the Bar Council of India is that the professors also must have some higher qualifications so that they can impart the education properly. As I said, like the college, university and colleges, the professors are also required to be approved by the Bar Council of India so that the education is properly given to the students, which is required in the courts of law. I got some difficulties. I was at the students attendance in the present circumstances where we are in the lockdown. What will happen is that your presence will not be properly fulfilled. So what will happen is that Bar Council may have to de-recognize your degree if that doesn't fulfill the requirement of attendance. The Bar Council may have to bear in mind the present circumstances in first. Then there are some problems regarding the professors requirement. I was told that they are required to pass NET. The NET examination is required for the other education, okay, but so far as the legal profession is concerned, it does require some separate consideration than the consideration for the other studies. The other studies do not require the viva voce every day. The Bar Council is controlling the education because the lawyers have also to have everyday viva voce. You are arguing before the court, and also presently you have to reply certain things. Presently you have to change your shift your position here and there because of the development in the case. What happens is that the legal education which is imparted, if you don't have proper attendance and proper training by the proper teachers, you will fall short, and it can't be then fulfilled any time in your life. Now, so far as the machinery of colleges, etc., is also required to be seen by the Bar Council of India. Bar Council doesn't only recognize the colleges and universities, colleges and students as it is. They have to see that the proper atmosphere is created to impart the legal education in a conducive atmosphere. For that, the classrooms, etc., have also to be of dimensions which are required for proper and easy education. I've got some difficulty in starting. I'm sorry. The constraints of the students going to the college the professors going to the college opening, etc., are all locked down. Of course, it is not in all colleges that it is material, because this is not the time when the colleges impart education during this period. Ordinarily, examinations are expected to be conducted. But there is a situation in India where, say, northern part has the different atmosphere than the southern part. So what will happen is that the college timings, etc., college education, college say curriculum, etc., would be a bit different in every part of India. What happens is that there are also different types of laws. The question arises more often in a student getting himself transferred from one college to the other. What happens is that a southern Indian college student wants to go to the northern Indian college. What will happen is that his presence, etc., his curriculum, his you see, attendance, etc., will have a bearing on that. Therefore, the Bar Council also does require to take into consideration this aspect of it, because the students who are studying in one college or one university and go to the other university or other college, the study which he has you see undertaken, and study which is to be imparted may have some gap, sometimes some overlapping. Sometimes overlapping is all right, but so far as the gap is concerned, that cannot be fulfilled if if the presence mark, etc., is not condoned. So those are the aspects which the Bar Council may have to bear in mind while you see controlling the education all over. So far as the process, you see qualifications, etc., are concerned, they are prescribed by the Bar Council, of course, but there is a practical side of it. In our times, the lawyers were coming as professors because there was no, you see, full-time professors were not available. So lawyers were coming in our time. College either were in the morning or in the evening. The reason was that the advocates would be busy during the court time, and therefore they could not. Now they have stopped the advocates, but nonetheless, what is required is that more often the practical side of it is required to be taught to the students, those who want to practice. Those who don't want to practice is a different matter altogether. So, and one more thing that I would like to point out is that at occasions you must be trained by the judges. You must also be trained by the advocates, senior advocates, and also the difficulties of starting practice, etc. It does require that not only an examination is taken for starting the practice as a lawyer, but there must also be some training for that. Now there is one hitch there. If one wants to start, you see, legal practice, what will happen is that there will be a period where he will not be earning anything, and you see, he will have to learn how to present the cases, etc. So there must be some arrangement by which, for a definite period, maybe say 5 years, 2 years, whatever the ultimate Bar Council decides, there should be a stipend paid. I am told that some of the areas are paying the stipend, etc. But like the doctors who are taking the higher studies, they are paid some salary, etc. Like that, there must be some arrangement made for the people who want to start the legal practice after the study of law. I'm sorry, Professor. Will you kindly excuse me? Will you kindly excuse me? I'll not be able to. There was some problem. I leave. I leave. I'm sorry. I'm sorry.
Okay, sir. Thank you for your words of wisdom. Now I will request Advocate Jayant Jaibhave, sir. But before his session start, I will introduce him. Advocate Jayant Bhave was a member of Maharashtra State Law Commission from 2000 till May 2012. Member of Bar Council of Maharashtra and Goa, statutory body under Advocates Act 1961 from 2004 to 2017. Act as a chairman of Bar Council of Maharashtra and Goa in the year 2010 and 11. Vice chairman of Bar Council of Maharashtra and Goa in 2008 and 2009. He is working on various legal educational institutions and legal aid committee at state level. He started first computer law library in India at Nashik in 2005 through Nashik Bar Association. He established computer law libraries throughout the state of Maharashtra and Goa at 425 places through Bar Council of Maharashtra and Goa. Sir initiated continuous legal education program through Bar Council of Maharashtra and Goa for training lawyers having practices up to 7 years, and he has given training to 3,000 young advocates. Sir initiated training programs for young advocates to appear the exam for judicial officers, judicial service as a career through Bar Council of Maharashtra and Goa. So near about 250 advocates joined judicial officer service after completing this program. Sir has worked as a panel judge about 125 different lok adalats. Sir participated in legal awareness programs of He also organized awareness programs at state level to member of Governing Council of Maharashtra National Law Academic Council of Maharashtra National Law University Mumbai. Is a member of Legal Education Committee of Bar Council of India Delhi. He is acting as an advisory committee of Bar Council of India. Books, that is Civil Pleading Convincing in the year 1996, Cross Examination, Civil and Criminal 1997, CPC Approach to Civil Trial 2006. He also published Hindu Succession Act in 2006, Law of Wills in the year 2009, and also published a Marathi book on CPC in the year 2009. So, sir, this is a very short introduction I have given. There is a large profile of yours here with me. So, without disturbing and much taking of your time, I will ask you to continue with the session, sir, with your topics. Thank you, sir.
Thank you very much. I'm glad to participate in this webinar organized by Hindi Vidya Pracharak Samiti, College of Law of Ghatkopar, all the respectable trustees of the college, honorable principal, and all the honorable teaching staff of the college, my friend and guide, Professor Nambiar, Honorable Justice Vyas, all other dignitaries who are participating, and dear law students, brothers and sisters. In fact, the questions which you have sent to me are more material, because there should be a good dialogue rather than a lecture, because the lecture perhaps gives a temptation to the law students to leave the classrooms many times. And therefore, if it is in a form of dialogue, perhaps I feel that they will be very well understanding the thoughts which we have, because naturally there is a gap of a generation. And out of that, a dialogue is the best platform. So I will be taking the questions and answers which are sent to me for first, and then I can express my whatever thoughts on the subject which you have given for this webinar. There are two questions, and I will take that last. What is an impact of COVID-19 on a judicial system? Two questions are there by two different students. I will take it at the last. There is another question that what is the importance of a local language? What is the role of a local language in a judicial system? The judicial system is for the litigant. It is not for the judge, neither it is for the lawyer. How skillfully you argue is not material. What is the understanding of the litigant about his case and his side being properly put before the judge, and thereafter whatever the decision has been given, out of that decision justice has been delivered, is at most important. Because you know the principle of justice. Justice is not to be done. It should be seen to be done. What is the meaning of this word, seen to be done? So it should be open, it should be transparent, it should be known to that particular person individually, and it should be known to the society as such in general. More important is of a society. If a person is to be punished for a criminal particular offense, it's an obligation of the state. It is not an obligation of the victim, because a loss may be to a particular victim, but it's a question of civilization which should exist. And because of a crime, a civilization has been affected. And ultimately, therefore, it is a role of a state to prosecute the accused. And therefore, it is important that justice is to be done, but it should be seen to be done. In that particular aspect, or on this philosophy, if you go to the language of the litigation, it should be in a local language. It is absolutely an important. What is the thought of the judge or the lawyer is of not an importance, one thing. Secondly, what is the practical aspect? If you are going to practice on a criminal side, you are not going to get an FIR in English or in any other your longer language. Whatever may be the state of the language of that particular state, that will be the language of the documents. So it may be FIR, it may be a complete charge sheet. This entire thing will be in a local language. If we are in a Maharashtra, it is in a Marathi. So you must learn that. You may be studying in any language. Unless you learn that, there cannot be a proper understanding of the facts, and therefore importance of the language cannot be ignored, or it is of the prime consideration. One who wants to practice in a state of Maharashtra, he must have a complete knowledge of Marathi language, unless he will not be able to go to the roots of the matter and deliver a proper justice. Secondly, witnesses which are coming to the court, the questions are to be asked in their language. You can't ask a question in English or Marathi to a person, in English or Hindi to a person who is of a Marathi origin. Ultimately, entire show goes for that litigant. He is a consumer of that justice. We all are the supporting infrastructure. It may be a judge, it may be the lawyer, it may be any office bearers of the courts. They are helping for the justice. So the litigant is the consumer. He's paying a court fee stamps. He's paying advocate fees. And therefore, being a consumer in a philosophy of a consumer also, it should be the language in which he understands. And moreover, what is justice? Natural principle of justice says that the matter must be communicated to a person in a language which is known to him. And therefore, considering all these aspects, my appeal will be that It is a different thing that you can learn a law in an English, you can argue the matters in an English, but if you are going to practice in a particular state, it may be a state of Maharashtra, it is Marathi. If you are going in a Gujarat, it is Gujarati. In any other language, wherever it is there, accordingly you have to go. You can go to the Civil Procedure Code, you can go to the Criminal Procedure Code, you can go to the Civil Manual, you can go to the Criminal Manual of the courts. There you will find that the language of the court, except for this Mumbai, it is compulsory Marathi. In Mumbai, it is optional. You can use English also. You can use Marathi also. If a question of having an interpretation of any version, statement of witness is to be considered, if it is disputed before the courts, it is always his local language, and the evidence, his deposition in that local language is referred, though the matter may be recorded into two languages. In a criminal matters like a sessions, the matters are recorded into Marathi also and English also, because it ultimately goes in an appeal to the high courts. In all other matters, most of the matters, the matters are recorded into Marathi language. But if question of interpretation comes, it is a settled law that always the local language of that person, that witness, which is his mother tongue, will be considered. So it is absolutely of an important that must be known, and also it is a responsibility of the law teaching institute to give this concept to the law students and teach them into that particular area to understand the proper local language. Then there is another question, guidelines to the universities. What is the guidelines to the universities? Guidelines to the university, as far as the course of LLB is concerned, it is a simple guideline that your law degree must be useful. It must be relevant to the time and context. Now it's time where we all are discussing that really a law degree which the colleges and universities are giving, whether it is a useful degree, whether it is an applicable degree. In a courts of law, we call that if a civil suit is to be granted, the ultimate result, those who have completed the CPC, that decree will be given. Decree means ultimately hukumnama, the ultimate result of the civil suit that can be executed, that can be enforced from the courts of law. So decree of the civil courts are two types. One is executable decree and another is paper decree, non-executable. We will have to give a consideration the law degree which today we are taking, whether it is really an applicable degree or it is paper degree. That's a question for a discussion before the law institutions also, bar council also, high courts also, and supreme courts also. Simply it is a duty of the university to consider all these aspects, make the suggestions, make the discussions with the law colleges, render that to the state government, render that to the bar councils, and modify from time to time their degrees, their courses, and their curriculums. So that is the responsibility of the university as far as the LLB degree is concerned. Universities are the executing body. The directions, the policies are decided by the higher bodies like councils in any field. It may be bar council, it may be medical council, it may be architecture council. For the professional degrees, the policies are decided by the councils. The state can give their own policies, and ultimately it's a responsibility as an autonomous body of a university to implement that particular aspect. So that is the importance of the university, that is the role of a university for the LLB degree is concerned. There is one question from a teacher. She says that as an educator, what she can do for the students. And further, she says that particularly the student who can't cope up, who are coming from the some depressed class of the society, those students who don't have an access to the technology, what she can do for them. Good. Many things can be done. First of all, as a teacher, there should not be anything in the mind of a teacher, as per my perception, that from which class a student comes. A student is a student. Whatever is to be done for the student from higher class, student from a superior class of society, and whatever is to be done from the student coming from an inferior class of a society, the Constitution says that you have to apply equally to the both of them. So there cannot be a differentiation for the student, but as far as the teachers or institution is concerned, what way they can do for the superior class and what they can do for an inferior class. But good, it may happen that a person affording a mobile and a person not affording a mobile are the two classes, which is also a reality of the society. Now the mobile has become such an easier instrument that anybody can have a mobile. That is a different thing. But as an institution, as a teacher, these all infrastructures are very easy now. If you ask me, if your law college is ready, I can definitely through State Bar Council help you to give a free software of the law reporters from many agencies. That is free. If you are having a mobile, then you need not pay for getting the softwares of the various companies where the case laws and the interpretations of law will be available. That is available. The development of the technology has made the legal education cheap. Cheap in sense, with of a less cost I'm talking about. It's not costly now. Comparative to the other modes, the information and technology mode is with a less cost. So the centers can be open. There, the law students can make a research on the computers. A IT library can be established. Just now it is said that we established the first e-library, law library in Nasik. It's true. In 2005, by using 5 lakhs rupees fund, we established a first e-library at Nasik. And thereafter, we established 425 e-libraries at different places of the state of Maharashtra and Goa. And for that entire library, we have to spend 1.5 crores rupees. And if today I'm going to establish that library, this was done in somewhere in 2007-8. Since that, the libraries are working. And if today we are going to establish a new library, we are establishing now at each courts a e-governance convenience center, where the lawyers will use the courts arguments, we will do the arguments through virtual courts. That centers we are going to establish at every bar association with the help of a bar council, Maharashtra Bar Council. So for that purpose, I am sure that at one place for establishing all these things, there will be no more expenses than more than 2 lakhs rupees. The more expenses will be for furniture. The instruments will be of not much cost. Therefore, all law colleges should have all softwares, all important softwares. They should have their computers in comparatively by considering the strength of the students, so that every student will have an access to that computers, and that particular e-library should be developed. The institution can develop there. Even in a particular law college, there are 1,000 law students taking the legal education in the all classes. I personally feel that 50 computers are sufficient to deal with, and they can be used by the law students. So this is sufficient. And for that purpose, the purpose should be understood by the institutions and the teachers, and accordingly the dialogues can be made. And therefore, I particularly give an importance to this question, that this aspect of considering the need of the needy law student is important, and that has been considered by teacher. I'm thankful for her for that purpose. The another question is that Bar Council, whether Bar Council's approach is of a quantity or a quality. A question has been raised. And a question is that without an elementary knowledge of the law students are entering into profession. Therefore, why you are not changing your rules and laws? That is a question in short which has been asked. That's correct. As on today, there are 1,600 law colleges in an entire country. And we are confident, we know that out of that 1,600, at least 600 law colleges are with not proper infrastructures, proper standards, and that's why the law students who comes out of that particular law colleges are not up to the mark. Also, we know that on an average, 1 lakh law graduates pass out every year through the country. If you ask me about the state of Maharashtra, near about 10,000 law students takes their law graduation every year, because every year we enroll near about 7,500 advocates. So about that, some may go to the legal, other services, etc. So approximately 9 to 10,000 advocates, 10,000 law graduates takes the education. Now the question is that controlling all these things depends on the one, policy, what should be your criteria. Secondly, even it is a question of the states and their will. And thirdly, upon the constitutional provision, right of profession, right of education is now a fundamental right. In fact, it is expected that every citizen should be given a legal knowledge. Some of them can come in a profession. There can be a different courses where the legal knowledge can be given. One question is there, that why you are going for an entrance when it is expected by the constitution that ignorance of law is no excuse. Correct. Ignorance of law is no excuse is the one of the principle which a constitution recognizes. But what is the real arrangement for a common man? That he will be explained about the laws. He will knows about the niceties of the laws. He knows about the new passing of the laws. What is an arrangement for a common man? Apart from the law student, ultimately we are coming from a society. We have to think of a society. So in this backdrop, controlling law college, we are trying. We are putting much restrictions. We are putting different types of rules and regulations also. But apart from that, there are certain laws. Even the Supreme Court has interfered now, and Supreme Court has constituted some committees, which committee will scrutinize the quality of the law colleges. So that depends on entirety, because as a fundamental right, we can't restrict anybody's right to take the education. We can't restrict anybody's right to start the institution. It's there. You know all the famous case of a Pai Foundation, that starting an institution is a fundamental right. And therefore, in India, it depends on that. Of course, as a governing body, we are putting more and more control, and we will try to find out that it's correct expectation of a new generation that the quantity should not be there, quality should be there. And therefore, with that background only, the entrance exam is started. In Maharashtra now, if a particular person has to take enrollment, there are two conditions. One condition is that he must pass the AIBA, All India Bar exam, in a 2 years period. And second condition on his there is that he must undergo 8 days continuous legal education program, CLIPS, where the basic training for the practice will be provided through Bar Council by calling upon the experts there and making a discussion on the law, explaining the various procedures, laws, its principle. So these two conditions are there. These conditions are only with an intention to have a good quality in a profession. Many times it happens that it is desired that the quality should be there. But in the jurisprudence, I must tell that it is always accepted by all jurisprudence that individuals are against the rule of the law. If certain restrictions are there, I personally feel that that restriction should not be for me, but it should be for the society. And therefore, our experience is that whenever some restrictions for the want of qualities are put upon the legal education, many times we have to face the agitations, we have to face the protest. These all things goes on, but as a governing body, I personally feel that we must give an importance to the quality, and that is also the responsibility of the concerned institution and also the concerned universities. So we are controlling that. We are keeping close eye on this particular aspect. Then another question is that no correct judgments of superior courts are coming. In United Kingdom, Supreme Court handles only 60 cases, whereas in India, 5,000 cases are handled by the Supreme Court. Why Bar Council of India is not taking any steps? I personally will say that we can't say that there are no correct judgments. A judgment is the law of the land. And if it is not correct, it is always subjected to some scrutiny. And it's welcome in India. It is a democratic country. It is with all liberal and open and transparent type of the working in all fields. Even in a judiciary, though we require some more democratization of the judiciary, though it is working in too conservative ways, still it depends on the need of the society. The justice depends on the need of the society. United Kingdom, today I don't have an exact figure of their population, but personally I feel that it should not be more than 20 crore rupees, 20 crore people or like that, whatever it may be. I don't have. We are with 130 crore of the population distributed in the various types of the states, caste, cultures, different types of languages. With all this, a dispute arises. No doubt, it is a need that the number of judges should be increased, and that is a working of the that is a motto of the Bar Council of India also, and the State Bar Councils also. We have given statistic. Today, we are having 15 judges, 15 for 10 lakh population. Whereas in all developed countries in the world, it is a minimum 50 judges for per 10 lakhs population. In Supreme Court, when Justice Altamas Kabir was the Chief Justice, he called a meeting of all Chief Justices, all Chief Ministers of the state, along with the central government, its law minister, prime minister. They sat together and they worked out and they declared that there cannot be a good functioning unless and until there are 50 judges per 10 lakh population. So to that ratio now, they are trying to do. In Maharashtra, now slightly increase of number of judges are there. We are reaching 15, 16 judges now per, it was 12 or 13 judges per 10 lakhs population. But ultimately, till it achieved, because it requires a budget. And unfortunately, the budget of this country for the judiciary is very less. That should be understood not as a lawyer, not as a judge, but as a citizen also. And it should be demanded democratically. Today, from last five budgets, you can go to the budget and see what amount from a budget is given to the judiciary. It is 0.10%, 0.10%, 0.15%, 0.14%, 0.26%. 0 point I'm talking about. And therefore, even if it is 2% of the budget allocation for a judiciary is not at priority, friends. Because of that, there is no funds proper, there are no courts proper, there are less number of judges are there. It's not a question of only judiciary. It's a question of an entire country. So as a citizen, we should understand and we should agitate. If that is increased up to 2% of the budget also, then I personally feel that Supreme Court will be working more comfortably. So we can't make our comparison with the UK. It's a different society. It's a different budgets also. It's a different mental states also. And therefore, whatever Supreme Court is today working, they are trying to their best out of their own, whatever the burdens they have. Even the high courts are working, and they one high court in particular one day is trying to touch 80 matters. So great efforts the judiciary is doing for all the people. And therefore, we all are begging on the judiciary. That can be a simple dispute, that particular person, whether he can have a dahi handi on a road, And also another dispute that whether the 8 persons can be hanged or not, or a corporate sector can get an exemption of 10,000 crores rupees of the tax. Everything goes to the courts, friends. So we are too friendly to the litigations nowadays. Public interest litigation has becoming a personal interest litigations. We have to change also. Our mindset should be in accordance to the foreign countries. If a dispute goes to the foreign countries about the bank loans, and if you take the comparison of that foreign disputes with an Indian disputes, in that dispute, that particular person only makes a dispute that some interest is more charged. And if it comes to an India, we start with this particular defense that this plaintiff bank is not a bank. The address given of this bank is not a correct address. Everything deny. And then at last corner somewhere, one line is written, which is the only truth, that interest is exuberantly charged. So this mindset of the Indian society, of which you all are, me along with all you are the part and parcel, we have to change these mindsets. Unless we change these mindsets, the burden of the judiciary cannot be reduced, friends. Then another question is that, what dynamic change post-COVID? So we'll take that question lastly. All COVID questions we'll take it lastly. Then another question is that how to build a career of the lawyer post-COVID. There is no question of pre-COVID or post-COVID development of the career of the law student as such. Law student in this 3 years course or 5 years course has to understood that this is the only opportunity to really study the books. Because once you are in a profession, you are rushing with the work, friends. You get a very small time to patiently sit and read the provisions of the law. Those who are really interested in the profession, they should by heart understand the jurisprudence. What is the jurisprudence? What is the jurisprudence of the criminal trial? What is the jurisprudence of the civil trial? What are the real meanings of the words? What is the difference between the motive and intention? When two words are used, there must be some difference. This all analysis of basics of the law is possible in a law colleges. Some years back, we had a lecture of Justice Mohit Shah, who was a 5 years Chief Justice of the Bombay High Court. And he, in his speech, told us that whatever good decisions he has given in his career as a judge, or whatever good arguments he has done in his career as an advocate, most of them were based on the basic knowledge which he acquired in the law colleges. That understanding can be further developed, but there should be a basic understanding. So law students should only think of developing their legal mind in a law colleges. They should not think that I'm going to be a criminal lawyer. I'm going to be a civil lawyer. I'm going to work in this part. Nobody knows what is their fate. It depends on the opportunity, it depends on his liking, it depends on his hard work, everything, many factors are there. So the only opportunity to the law student in the law college is to get a proper understanding of the legal principles. You do that, your career in all fields, whether it is pre-COVID, post-COVID, it will develop, friends. One question about the GDP is there. I'm not an expert on that particular aspect. So sorry, I can't give that answer. What practical training can be facilitated? Yes, that is important. Here now, we must admit, now the law colleges, the honorable principals, the managements, everybody is there. And we must admit that we are not able to connect the academics which we are giving in a law college of law with application. What is the difference between the degree of the law and what is the difference between the degree of the medicine? You just make a comparison. If anatomy is taught into the medical college,
The next day, the student gets an opportunity to see the body. And in a body, the knowledge of anatomy, which was taught to them, is explained by just giving the sketches to the body. This is academics. This is your application. Here we are lacking one part. Second part, I must tell that with due respect, now it's a time of a full-time teachers. There was previously an era where the part-time teachers was recognized. UGC has not accepted that. UGC has given different modes, and part-time teachers who were mostly the practicing lawyers coming to the law colleges have stopped now. You may have some now lectures of the practicing lawyers. They are coming as the guest lecturers. In a course, entirely course, the person who do practice is not teaching the law. And person who teach the academics is not practicing. This is the difference, which must be, where we should find out some solutions, friends. The academics is required. There must be academic knowledge, and that academic knowledge can be given by the professor, by the teacher. If you ask the practicing lawyer from a court and come there in a law college and give an academic lecture of 45 minutes, he will be not successful, because it's not his job. He can't make that particular type of the delivery of a lecture there. But if you are making a combination of these two things, the professors will give their academic knowledge, and the practicing lawyers will be associated with the law colleges, and they will share their experience, and they will teach, or they will give a sharing of an experience how this particular knowledge is to be applied now. This second is required. We are trying to do in a legal education committee now, and we have made an appeal even to a legal services authority, which are established at all centers, that you be a mediator. And through this mediation, there should be a collaboration of each legal teaching, law teaching institute with the law practicing institute, that is the bar associations, judiciary. And as in a medicine, compulsory the course are designed, that should be worked out. So it will come out in a short time, but till that time, still it is possible. The particular time after in a pre-law colleges, particularly in a 4th year and 5th year, the law students must have a different weeks. They should have a week of drafting and convincing, how the agreement for sales are to be drafted, how the sale deeds are to be drafted, what are the minimum requirements. The questions can be given, and they may be asked to make that particular drafts. These drafts are going to give them an earning when they will enter into profession. Somebody will come and say that I want to purchase a flat. Then he will not take that man to some senior person. He will draft himself, because he understands what is drafting. He will not have a burden. It's a simple work. Some simple understanding is to be kept. Many typists do that job. Many stamp vendors do that job. Why the lawyer should not do that job? There can be a week of having an understanding of a criminal trial. What is charge sheet? Charge sheet is to be read in a classrooms. What is FIR? After FIR, what is the investigation done by the police? Which statement is recorded? Which particular panchanama is drawn? How that panchanama is drawn? If that panchanama is of a seizure of weapon, how it is different than other? 1, 2, 3, 4, 5, 6 aspects of the charge sheet should be they are explained to them. And ultimately, what is charge sheet? Then after charge sheet, what are the stages? Which are the trials? Warrant trials, summons trials, summary trials, sessions trial, special trials. These are all different types of trials. They should be explained. If it is civil court, what is a pleading? How suits are drafted? What is order 6, order 7, order 8 of the CPC? Why that particular formats are there? Why it is to be written as a special suit? Why it is to be written as a regular suit? Everything should be explained to them. With this interaction, we will try to minimize the gap between the waiting period of the law student after getting a degree in a bar room. It is criticized that bar room works like a waiting room. It happens If you are not practically working and if you are taking a degree of law and entering into a court, you will be foreigner there. In this 4th and 5th years, the law colleges should start that. We have started these types of a program. It is called as a trial education programs. 5 criminal trials and 5 civil trials. We have attached the groups of 5 law students with the practicing lawyers. One practicing lawyer will take care of 2 batches. One in a civil case, another in a civil criminal case. So 5 at least civil trials, 5 criminal trials. If he goes particularly with the stages with that particular person, and that is possible, all senior lawyers are always happy to extend these types of a help, subject to condition. The institution should give an importance to them. They should be called, they should be honored, they should be requested. If you are going to the, in spite of a busy schedule of the lawyer, he is always happy to share his knowledge, because after completing the practice of 25 and 30 years, every lawyer has in a mind that I should share something for the newcomers. He shares it for his junior, but a junior is a person when he comes in a court, he is with a degree. And he makes frustration that I'm not getting money, I'm not getting work. That types of frustration should not be there. And when he will go through as a law student, this frustration, this depression will not be there. So utilize your 4th year and 5th year properly and make a timetable along with your academic program and share that particular your time with that particular bar rooms, the courtrooms with systematic program. You can't sit there as a tour in some garden. It is observed that many times the courts complaints that the law students are not serious there. So you must be serious. As Lordship Vyas says, you must be properly dressed. You are now going to be the professional there. You can work as a paralegal worker there. There is a legal services authority at all places. Your college can be attached there. You can provide them the team. They are having a many schemes which are related to the people at large. You can take that scheme. You can go to the persons. You can go to the society. You can differently go to the worker society. You can go to the employer society. You can go to the builder society. You can go to the laborer society. You can go to the different classes, cooperative societies, take their experience, implement the schemes of the legal services authority to all these different sections of the society. So not only that, they will get the knowledge, they will develop their contact. From that contact, they will get their work. They will understand the society. They will understand the human being. The most important learning for the lawyer is that he must understand the human being and must try to become a good human being. He may be a scholar of the law. He may be full of knowledge. If his heart is not of a humanity, he can't do a justice. For a justice, only one quality is required, and that quality is of a humanity, friends. So try to be a good human being. So in a practical training, the college can do all these efforts and college can make this program. We as a bar councils are always announcing that you can approach us and you can take that. Why the entrance? Then another question is that why the entrance is there? That I have explained that the entrance is there because now we want to maintain the quality. Your own vision is that we must go for the quality. So for maintaining the quality, entrance is necessary. And Supreme Court has now laid down a law that unless entrance is there, now there should not be a admission to any professional courses. That's why entrance is necessary, friends. Role of BCI in a legal education. I will explain that. I'll keep this question pending. Then average to do some, I could not understand that question, sorry. Why court can't work long hours? See, courts are not to be counted on the basis of time. Moreover, law is logic and law is justice. Law is not a mechanical process, friends. Though nowadays it is said that artificial intellectual mechanism can be used. Still, computers can't take the place of the courts and judges. It's a human mind which consider that what is the correct perception of a justice, because ultimately we have to find out the truth. The breathe vakya of the court is Satyameva Jayate. You can go to any court and you will find that behind that court there is a breathe vakya, Satyameva Jayate. So finding the truth cannot be a mechanical process. And that's why, friends, when courts are working, court has to give a lot of thinking to the process. Without thinking, you can't make a proper justice. That is the difference of an Indian judiciary with all other developed countries. In China, the murder case is resolved in 60 days. Speed is there. Courts are working. Full time they're working. Whether justice is there, a question mark is there. Whether in a 60 days, you can just in a mechanical process finish up the life of a particular person, question is there. If a dispute of a child, when the father and mothers are disputing, court has to look not to the dispute, but to the welfare of the child as a custodian of that particular child with a full heart of motherly and fatherly feelings. So he can't work mechanically. He has to give some time. He has to give the time for the situation. And it is required that some time may go on. So it's not a question of working for hours together. Court may be working from 10:30 to 5:30. Lawyers may be working for 1 hour or 2 hours. Beyond that working, entire working, there are a lot of working. They are thinking, they are discussing, they are searching the law, they are finding out the ways. All this process is not counted in a time, friends. It cannot be counted in a time. So don't think of making some mechanical formulas when you work as a judge or when you work as an advocate, and even when you now studying as a law student. So there's no question of any fixing of a time, and because long hours will be fixed after a particular period. If I have made a cross-examination for 2 hours, the all psychological expert says that I have done the physical work of 12 hours. 1 hour of mental full stress work is equal to 10 hour physical work. That is the equation, friends. So you can't make that type of this figure working with the courts and the judicial working, at least, and at least the as if the constitution is there, friends. Then 1 year practical training. Dr. Bhagyashree, madam, has asked this question. I have particularly taken her name here because she seems to be the PhD, and she has asked a question that 1 year practical training mandatory completion for the LLB. Perhaps either she knows the case of V. Sudhir versus Union of India, or perhaps she don't know that. If she knows that, she want to test me, and if she don't know that, then I will have to test her because she's a PhD now. So, doctor, kindly go to the V. Sudhir case. This type of a mandatory practical training in the 4th year was started by Bar Council, which is struck down by the Supreme Court with certain observation. So kindly go to that authority. Your answer is with that. It is reported in AIR 2000 Supreme Court, and you can go to that V. Sudhir case. 100 pages judgment is there. Those who are interested to understand the law of legal education of this country, they should read that judgment. You will get the understanding. Then the another question is that what is a pandemic situation? Is there a way to study the law? Then another question is that the new strategies in a lockdown for a legal education, Indian legal, whether Indian judicial system is competent with the current world scenario and technology. See, this last question I will take first. The Indian judiciary is, of course, having serious problems. That problems are of an infrastructure, that problems are of a budget, that problems are of the strength of the judges, that problems are of the skills of advocates, that problems are of a technology. Everything is there. So in that comparison, in a legal system as concerned, in comparison to the world, current world, particularly developed world, we are lacking. We'll have to improve. We'll have to find out some more budgets. We'll have to find out some more buildings, good buildings, particularly at a small villages, because in a metro cities, they are there. We'll have to develop the law colleges also. The law colleges at metro cities and the law colleges as national law schools and the law colleges at small cities, they are also of a different scales and comparisons. In all this scenario, the Indian legal judicial system is lacking. That is really a truth. As far as the competence is concerned, competence to deliver a justice is concerned, we are toppers of the world. That should be understood, because we are having a topmost constitution in our hand. That constitution has been recognized as one of the best constitution of the world. You must have heard, friends, that it was in all the countries after the verification of and study of all the constitutions of the world. Indian constitution was said to be one of the best. So the execution of a constitutional principles, the courts which we are doing, they are of course the competent courts. They are delivering a good justice. We are lacking in the speed because of the burden or because of the infrastructure of finance, and also the important aspects of the mindsets of the Indian society. That is also important. For what purpose we are using the forums of the judiciary? The mindsets of the advocates. We'll have to change this. But as far as the competence on the part of the development of the jurisprudence is concerned, justice is concerned, evidence is concerned, procedure is concerned, we are absolutely competent. We don't have any incompetency in that particular aspects in comparison to the world. In all other aspects, we need a development. And for that purpose, we can fight out. So it's question that whether you are going to give an importance to a cosmetic look, or you will be going to give an importance to the spiritual look of the personality. That is to be a perception of an Indian citizen. If you are on a cosmetic look, yes, we are lacking. Definitely, too much lacking. As far as the spirit is concerned, spirit of justice is concerned, we are not lacking. Neither our bar is lacking, nor the judiciary and the judges are lacking. We are absolutely up to the marks, and we can be said to be the topper, because we have a best philosophy of the justice in our hands. So that can be my answer as per my own perception, friends. So lastly, coming to the impact of the COVID-19 on the system. COVID-19 has not given an impact on the legal system. It is given an impact of the social system of the India. In a Marathi, we call that आपण जमिनीवर उतरलो. हवेत फिरत होतो, जमिनीवर उतरलो. That is the situation for all the fields. Why only the legal field, friends? The courts are not working from last 75 days. It has not happened in the history of the courts till the Supreme Court was established on 1774. Supreme Court in India was established on 1774. Till that time, it has not happened. So friends, COVID-19 has given an impact to entire thinking. Now here in a judicial system, we'll have to be cautious of not taking an unwanted litigations to the courts. But at the same time, we must develop the sense of justice amongst the judges, advocates, and citizens. That is a social responsibility. To that particular aspect, I will make an appeal that there are a lot of opportunity in a judicial system now which can be taken by the youngsters, because now the era of the further judicial system in India going to be a combination of open courts, of physical courts, and the virtual courts. It will be a good second between these two systems. We'll have to work for an important witnesses in an open courts. We'll have to make a chief examination, cross examinations in an open court. At the same time, if some PT witnesses are there, some expert witnesses are there, we'll have to use a video conferencing, and we'll have to keep all that persons away from the courts. That will benefit because their time will be saved. So many people will not be coming to the court, and short procedure can be adopted. When you are in a physical box, witness box, so many things happens that the matters go on delaying. The judge may be looking towards some other matter, some another advocate intervenes. The advocates have some difficulty. The matter is prolonged. Once it is in a virtual courts, the judge, the advocate, and the witness will be concentrated to that particular work. So now post-COVID, it is going to be a different judicial system. And therefore, there is a good opportunity to youngsters. Virtual court will be practically run only by the youngsters. We all old lawyers will be not well acquainted with that virtual courts. So you have a great opportunity, 50% opportunity without a competition friend there. You should take this opportunity. You should understand what is the e-governance of the Supreme Court now. The schemes are there. Now the many webinars are going. Even Dr. Chandrachud sir, Justice Dr. Chandrachud, who is a chairman of the virtual committee, e-governance committee, has delivered a lecture. Justice Jayabhave, who is the Chief Justice of the Karnataka High Court, he has given a lecture. All the law students should go to the YouTube and hear their live lectures. What is their perception toward the judicial system? That is post-COVID-19. So 50% work is available to you. Another advocates who may be practicing at mofficils, they can make a filing of their matters right from Supreme Court, High Courts, tribunals, from their local areas. They do not go there. They can make an e-filing. This is a big open area, and the competition is reduced now. There cannot be a monopoly. A particular person, he only works in a mat. He only works in a cat. He only works in a consumer. This is not going to happen now. Everybody can work. Show your skills. Show your diligence. Show your expertise. Go on expertising yourself. Make your skills more and more sharpened by keeping update of the law. And you will get a good opportunity, friends. So this is going to be a competition between the seniors and the juniors. And the juniors have upper hands now because the technology is in their favor. I even don't know how to operate the mobile. I have to call my son and I have to say that, please kindly help me. So I will call my junior. So he will be my sharer. And I will say that I want to argue before this court. Kindly help me. Kindly sit with me. He will help me and I will be comfortable. So I'll be sharing. Naturally, if I was not previously sharing with him some practice, I will be sharing some practice. So this is the bright side of the COVID-19 for the younger generation, personally I said. So law study is a continuous process in a law colleges, whether it is post-COVID or pre-COVID. I personally don't feel that as far as the law study is concerned, there is any difference. But as far as the practice is concerned, friends, there is a lot of difference. That should be understood. You choose your own methods, learn that methods. I must tell you, in a profession of the law, I can tell from 1960 to 2020, after every 10 years, there is a new law. In the 1960, the tenancy law comes, Kul Qaida. In the 1970, urban sealing land comes. In the 1980, the consumer law comes. In 1990, the DRT came. In the 2000, now all other NCLT, RERA, many matters comes. These are all the areas where you should pick up your practice. These are the areas where you will get a work, because the old established people are engaged in their old areas with old laws. They are working there. They are not comfortable to switch. If I'm in the practice of a civil trial, I'm not comfortable to go to the RERA court. I'll say that somebody should go. My client, I will say that usko mil do, wo karega tumhara kaam. So that new area you should expertise. But there you must be full of your preparations. What are the pleadings? What are the formats? What are the law? What is the case laws? What is the procedure? Where the office is? Where the registrar is? Where the court is? You should not be a newcomer in that particular area. You should be an expert of that particular area. So all the seniors will send the matters to you, friends. So try to develop your mindset in this particular aspect. It is not only the COVID. COVID has given much more opportunity to youngsters. But prior to COVID also, there was always a room, not only on the top, but for that particular era, for that particular period, those persons who choose that particular movement, then they understand what is the need of this particular time. They grown up, they are busy in practice. So my particularly best wishes for that. I hope that I have taken much time, though I was going to speak about something on a legal education and the role of a bar council. If you permit me, I will take 10 minutes, madam. Yes?
Yes, sir. Sure.
Yes. So the legal education, first of all, must be considered by understanding the history. The most difficult paper for the law students always is of a legal history. When I was in a law college also, I used to call my teacher, sir, why this legal history is there? What is the use of this legal history? But the question is that the perception of the lawyer and his approach toward the profession cannot be developed unless he understands what is his history. And that is for every professional. Architect must understand what is an architectural history. The lawyer must understand what is the lawyer history. Consider the state of Maharashtra. We have a great traditions. And that particular time when their codified law was not there, the dharma was law. But what was dharma? You can just take one example of the great jurist of this particular state of Maharashtra, Ram Shastri Prabhune. You know that history, that when the murder of Peshwa was done, and when he was asked that what should be the punishment, he says that truth is the basis for the justice, and my punishment is only a Dehanta Prashchitta to the prince of that particular time, Raghunath Rao Peshwe, that he announced. And therefore his name is always there in the history of the Nyaya Shastra, Ram Shastri Prabhune. He worked on dharma. But base of the dharma was not like today's kings, some sadhu making his own business on the basis of dharma, or some political party working for some this type of a dharma, that type of a dharma. That was not the only way of justice on the basis of dharma was the satya. What is a satya and what is a satya and what is satya? And to, without fear and complex, move on this path of the satya. Then came the Mughal period. And Mughal period, the base was of course Quran. And the wakil word, wakil, that is a lawyer, Marathi or Hindi, wakil, is an outcome of the Mughal jurisprudence. They give this word. He is the representative of the God because he is doing the justice. And then on that particular basis, in a Mughal period, the legal work, the legal profession was working. The wakil was there. Even in a marriages, you know, the wakil was there. And the wakil was asking to the girl, ki nikah kabul hai, kabul hai, kabul hai. Movie mein अपन देखते हैं. So that was the Mughal period. Then come British period. British period is the foundation of the modern legal system which we today adopted, and particularly the codification of the law. codification from section 1, 2, 3, 4 to section 40, 50, whatever these sections was converted. It was not there in ancient India, in a Dharma, or even in a Mughal period. Britishers brought this system because they were having a democracy in their country. Old democracy, 700 years, 800 years old democracy they were having. So they brought that system. They thought that if a proper business is to be done, there must be courts. Because in a business, the cheatings are there, the defaults are there. And if it is to be avoided, courts must be there. So at Bombay, Madras, and Calcutta, they established the courts. They established the Supreme Court also in 1774. And further, from 1857, they brought all the different types of courts, the system which we today even we are adopting, friends. Then come the pre-independence. In a pre-independence, the law colleges were started. The first law college is started in Punjab, friends. You can take in a legal history. In a Punjab, Anjuman-e-Punjab is the first law college started in somewhere back in 1857. Then the different law colleges culture come with the help of the Britishers and the local institutions. But the law colleges was not that way prominent. Neither there were night colleges or some, you can say, part-time colleges. These types of colleges were there. And then there came Constitution, where the great father of the Constitution, Dr. Ambedkar, gave an importance to the justice. You see the preamble of the justice. We have established a sovereign state which is socialist, democratic, republic. 4 words are important in the preamble. Republic. You see, what is republic? We call it as a Prajasattak, Ganatantra. Means it is out of the leadership elected by the peoples. Republic. It's sovereign. Nobody is above that. Nobody is going to control it. It's democratic. It's socialist. No religion will have an upper hand. All religion will be equal. With that, the preamble says that with this, we have to go to achieve the independence, liberty, and justice. Justice will be the core base. And by achieving all these particular things, independence, liberty, justice, ultimately what we have to do? We have to develop a fraternity amongst the citizenship. Is the basic concept of the Constitution, friend. With this, the law has further developed in this country and legal profession has been developed in this country. And then comes a making of the profession. The Advocate Act 1961. There is a judicial system as per Constitution. There are different pillars. You know that. The law-making pillar is there. The law executing body of a judiciary is there. The administration is there. These are the basic pillars framed in the Constitution, and they are independent to each other. If a judiciary is there, they have to interpret the law made by the law-making body. Law-making body will not interfere into judiciary. Judiciary will not interfere into law-making process. In between, the society is there. In between this society, the citizens are there. Advocates are their representatives. And therefore, the concept of the Bar Council is that it is a buffer agency between the law-making body and a law executing body. What is the requirement of the change of the law? What is the requirement of the execution of the law from a judiciary will be communicated to each others. And therefore, Section 6, State Bar Council. They will enroll the lawyers. They will make the welfare of the lawyers. They will conduct the misconduct inquiry of the lawyer. They will develop the thoughts of the law. They will make the knowledge of the law to the common man. And also, they will organize different types of a talk, seminar, this and that for developing the law also. That is Section 6. Section 7 is the Bar Council of India, where the basic principle is of developing a legal education. And then you see the legal education, how it is developed in country, friends. We have short time, but a Bar Council has a different organs. You should understood as an institution also, one should understood. There is a legal education committee. There is a Bar Council of India trust. There is a director of a legal education of a Bar Council of India. The law colleges can directly approach the director of the legal education of the Bar Council of India. What is your requirement of the curriculum? What is your difficulty in getting any subject or its teacher or the expert person from that particular faculty? That should be communicated to the director of education of a Bar Council of India. These are the organization. Out of this after establishing this organization, friends, the concept of the National Law School has been developed. And there is also now the control on the standard textbooks, the term of the courses, the different new courses. It's not only the law degree, which is expected to be run by the institution. It is also expected that your duty is to give some diploma course, not only for the professional, also for the common man, for understanding the law, for getting acknowledgements of the various new concepts of the law. It's a duty of the institution. You can approach this director of the legal education. They can develop there. Then there is a Curriculum Development Committee of the Bar Council of India, CDC. Here, you can make all representations of the curriculum directly to the Bar Council or through university to the Bar Council and develop your own courses. Don't depend upon the course given by the university. You can make a suggestions. Many professors are learned professors. They had a different concepts. If a legal education is to be developed, it should be an interaction of all the law professors through your institution to university, to Bar Council of India. State Bar Council is one of the helping organ for you, which are the local bodies. Then you can take that. Then there is also a standing committee of the Bar Council on the Legal Education Committee. So 5 institutions works for the legal education in a Bar Council of India. And you can use the forums of this 5. All the details of this committee, their working, their resolutions are available on the net. You can go to the net of the Bar Council of India. You will get all the informations of all this committee. Also, there is a National Knowledge Committee, NKC. You know that. You must be knowing that from 2005, the Prime Minister has established, and there is a different wing on a legal education in a National Knowledge Committee. So you can also approach them. We all together can develop the legal education. We have suggested why the law colleges should not have a subject of a logic in the law course. Logic is the base of the profession, and we are missing with the logic. I asked this question, and the answer was that we are not getting the teaching staff of the logic. So somebody from your law student should develop the logic. He can be a teacher. He will get hundreds of jobs. Other law students who want to develop their career, they should select such subjects which are available to you on information on these various committees. They're working. You can find out how the legal education can be developed. The moot trials, the moot courts are the arguments. But we started now the development of the moot trials. Nambiar sir has participated in our competitions, national competition of the moot trials. A civil trial will be conducted by the 3 lawyers. One will be the judge, one will be the advocate of a plaintiff, and another will be the advocate of the defendant. The witnesses will be from the colleges. Our NBT Law College conduct this moot trial from last 14 years in association with Advocate D.T. Jaibhave Pratishthan. And we had a national competition where we teaches them what is chief examination, what is cross-examination, what is oath of the witness, what is staff of the court, what is judge, what is a dictation of the judge, how we can take the dictation from the deposition of the witnesses, how the witnesses has to depose in the court, what is truth. Otherwise, the concept of the law student remains on the pictures. They learn CPC, they learn CRPC, they learn Evidence Act, but still they feel that witness comes from some doors of the courts. Mere paas ek chashmadir gawah hai. This becomes their impression. And with that impression, they enter into profession. Witnesses, चश्मदीर गवाह कभी ही दरवाजे से नहीं आता है, वो सीआरपीसी के अर्जी से आता है. सीआरपीसी के लिए उनको सीआरपीसी और सीपीसी से उनको दस्तावेज देना पड़ता है. No document can be produced before the court by taking from the pocket of the court of the advocate and handing over to the courts. Many films shows that, but there is a procedure. What is that procedure? How we have a filmy impressions, how we have some false impression, that should be actually carried out in the colleges. That requirement is there. We are promoting such activity. Institutions should take the interest. They should not just follow the procedure or the prescribed type of a curriculum which there comes to them. It's a question of the will of the individuals. It may be a law student, it may be a law teacher, it may be a management, or it may be the bar council. It is a question that really we are interested in developing the system. If we are really interested in developing a system, we must develop our younger generation. They are the future of tomorrow, friends. You all law students, you are a future of this country. You are a future of this society. You should develop legally. Today, the truth of the society is that if 100 disputes are occurring in a society, only 30 are coming to the legal forums. 70 are going to other unauthorized agencies. They are going to police. They are going to gundas. They are going to the political power makers. And there they are resolving without justice because there is no procedure. There is whim. What he understands, what that particular power holder make an understanding to whom he wants to favor, he gives a justice. And that is a failure of a justice, and that is also a failure of a democracy. So friends, we must develop our legal mind. We should not encourage any sort of an unauthorized agency. We can take the alternate modes. We can understand what is mediation. We can understand what is conciliation. We can understand what is lok adalats. That can be one of the paralegal forums. We can participate in that, but we should not participate in any unauthorized agency. It is not the duty of a lawyer or a law student to go to the police stations for any sort of a bargain with the police. It will be a most unauthorized way of working. So there are certain professional ethics of this profession, and I hope that when you will enter in this profession, you will understand that with a good spirit, you will carry forward that. If you are becoming a good student, and if you are becoming a good advocate out of that, that is not only a success of an individual, it is a success of your family, it is success of your institution, and ultimately it is a success of the society. So my best wishes, and I hope that I have done justice as expected by your institution to the subject. Thank you very much.
Thank you so much, sir. You have very beautifully expressed all the concept which we are expecting from you. I think all the participants are also satisfied today by your clear concept of each and every point. So today you have given the aspect about the foundation, 5 foundation case also, quality of the advocates. You have enlightened about the Advocates Act 1961. You have also enlightened the committees of the Bar Council of India. A special things you have, sir, quoted today about the quality of the humanity also. That is very important part, sir, you have quoted today. So you have also cleared the concept for the students for developing their minds through the colleges. Proportion of the judges with the populations comparing with the countries. And how and why the CET, that entrance test, is very much important for maintaining the quality of the students. The students, how they can pick up the area for their expertization. So we are very thankful, sir, for giving your special time with us and shared very great knowledge with us. I am also thankful for the Justice Vas, sir, for giving the knowledge about imparting of the education by the professor, their approval by BCI. Even also he have thrown the light on points regarding the everyday Viva course. That is through the presentation in the development in the case. Proper training should be given to the teachers. Even the training through the judges and senior advocates before practice by the lawyers, how it is and why it is necessary. So I'm thank you on behalf of Hindi Vidya Prachar Samiti. Now I will request Neha madam to give a vote of thanks. Neha madam?
Yes, ma'am. Extend a hearty vote of thanks to our esteemed guest speaker for the day, Justice Vyas sir and Advocate Jaibhave sir. It was indeed a great privilege to have you here with us. I am sure that every listener present here feel enlightened by your extremely vast knowledge and exposure you have given to us on the topic of BCI rule in the context of legal education, jurisdiction procedure, advocacy with the reference to COVID-19. We thank you, sir, for having spread your precious time with us during this lockdown. I would like to thank our very supportive management, Hindi Vidya Prachar Samiti, for giving us this platform to host this webinar. Sincere thanks to our Honorable Secretary, Dr. Rajendra Singh, sir, Director, Dr. Usha Mukundan, madam. Special thanks to our workshop convener, Dr. Mrs. Madhura Kalamkar, madam.
Hello everyone. I think there is a disturbance from net connection of Neha madam. Jaibhave sir, are you there?
Yes, I am there.
Sorry to take your one of two of questions are there, which remains by me to ask you. Can I ask you, sir? Yeah.
Yes, definitely.
Thank you, sir. So two questions are there. Which are the welfare schemes meant for practicing advocates envisaged by BCI? And is there is any provision entitled the advocates by health, insurance, loan facilities, and pension benefits? So please highlight on this point.
In a Bar Council, there is a Rule 40 of the Bar Council of India rules, which is a medical scheme for the practicing advocate. When you are enrolled as an advocate, a certain amount, maybe up to 3,000 or 4,000 is taken as a contribution for a Rule 40 from each lawyer as a compulsory contribution. If he is not paying that contribution, he cannot be enrolled. But once he is paying that particular contribution, then as on today, he can be helped in any case of his medical emergency, medical help, or any hospitalization, up to the extent of 1 lakh rupees. 50,000 rupees are contributed by the Bar Council of Maharashtra and Goa, and 50,000 rupees is contributed by the Bar Council of India. This is one scheme which is called as a Rule 40 scheme. Then subsequently, there is also Advocate Welfare Scheme of the Bar Council of Maharashtra and Goa, where the advocate, without any contribution, if he suffers from any serious illness, such types of a heart attack or any bypass or any sort of a serious illness which is danger to his life, or in any unfortunate case, if an advocate dies, then up to 1 lakh rupees, a help can be given from a advocate welfare fund. This is another scheme which is there. As far as the other scheme is concerned, there is the Advocate Welfare Act of 1980, where independent membership is to be taken. It's voluntarily till today. We are trying to make it compulsory, but this is an independent scheme where a different trust is established, where two members, it is a trust established by the government of Maharashtra, where Advocate General is the chairman of that trust, and two trustees are from the Bar Council of Maharashtra and Goa, and another 6 trustees are appointed by the state government. So out of that trustee board, if anything wrong goes, if any person is retired or any person is ill or is disabled, some help can be given. The amount is meager there because it's an old act. We are trying to enhance, and our aim in future aim is that at least up to the 10 lakh rupees in case of a permanent disability, death, or a retirement after 30 years, the amount should go to the advocate, for which we are working. As on today, the amount has been restricted up to 3 lakhs rupees. So these are the 3 existing schemes. Apart from that, now and presently, considering the scenario of a COVID-19, if a particular person is affected by the infection of a COVID-19, then the Bar Council has taken a decision. In case of his illness, some additional help can be given from a general fund. And in case of death also, the additional fund can be given. Recently, we have given such type of a help to some of the lawyers. So these are the different schemes. As far as the pension is concerned, it is not possible to arrange till today. We are working on that. Basically, the advocate, once he is enrolled with the Bar Council, whatever amount he pays to the Bar Council, that is the only fund generation for the Bar Council. There is no government grant, there is no any other fund, and with that particular fund only, we have to run the entire show. We have to conduct the various training programs, the educational programs, seminar, the help to the medical aid, to the contingencies of the some sort of a death and accidents to the lawyer. And in that particular scenario today, as on today, it is not possible to have a pension scheme. But now we are seriously working of affixing the 50 rupees payment. Previously it was stamp, now it will be a digital payment at the time of filing of each wakalatnama by each advocate in each matter. And out of that, now we are going to establish a good fund where some sort of the good schemes will come for the lawyer. As far as the insurance is concerned, group insurance are always floated. We get a less response. They are very well designed policies. We can say that it's a tailor-made policies. And out of that tailor-made policies, you can get a benefit of the medical aid. You can get the benefit of the accidental death also. That policies are working repeatedly every year. Bar Council is publishing that particular, but they are available to the advocate who is enrolled with the Bar Council or the family members of that particular advocate. So these are the present schemes which are available, and we are trying to do better.
Okay. So one more question is there. Can Bar Council of India consider to allow the working law colleges faculties, including principals also, and even the other people, those who are surrendering their sanad, and those who are working with the private firms or private what we can say in a private factory and all. So whether they can enter into a private practice for limited purpose, such as providing free legal education or free legal services to the poor and needy litigants under the agencies like District Legal Authority.
Once you are out of the employment, and once you are having a this law graduation certificate, you are entitled to be enrolled with the Bar Council. Here the condition is that you should not be in an employment, any gainful employment or otherwise. That is the only restriction. If you are in an employment in any condition, you can't be allowed to practice the law. Voluntarily doing is a different thing. But signing a wakalatnama and representing a particular person as a lawyer is a different thing. If you want to do this as a profession, as a legal profession, you will have to surrender. You will have to come out of your own employment totally. You can't make a suspension of your employment and then enter. You will have to undertake that I am in no more employment at all. And then only you can do that. Only the exception is the legal service. If you are there in any legal service as a judge or some legal officer, you are working, in that time your sanad can be kept suspended till you are in a service. And after your service is over, if you are out of service, your sanad can be again resumption to the sanad can be given. That provision is there. Otherwise, this particular type of restriction is there.
Okay, sir. That means the advocates, those who have taken their degree, but they are working with the government sectors. So they have to surrender their sanad and they cannot practice.
No, they can't practice.
Okay. Sir, my last question is to you that you have already discussed about the paper degree. Sir, on that I want to ask you, many of the students, they themselves are now ready to come in the college to attend the regular lectures. So what kind of actions we can take? That means law colleges, what kind of actions can be taken by the law colleges?
You can restrict them from entering to the examinations. That power is there if they are not, 70 percent or something. I'm not exactly on a percentage. Presence is compulsory. And if you are making a report that to the university that no such a type of a present is there, then he cannot be permitted to appear. So quality depends on everybody. Quality, Bar Council also see the good policy. Quality, the educational institution should also do their discipline work. And the quality, the law students also do their discipline education. Together we can talk about the quality. If we are keeping loose falls here and there, the quality is going to be affected.
Thank you so much, sir.
Thank you.
Thank you for giving your precious time today. On behalf of Hindi Vidya Prachar Samiti, I will thankful to everyone, all the participants, principals, and all the students for attending today's webinar. By this, I'm going to end with the session. Thank you, sir. Thank you all.
Thank you.
Greta madam, you can end the session.